January 13th, 2022, 1 p.m. We are at the Sunny West Conference Room, and we'll now call this meeting to order. I would like to just say we are joined today by Interim Metro Clerk Austin Kyle and Deputy Clerk Sean Reed. So we appreciate their being here, and I will ask the Metro Clerk to record the roll. Thank you.
Ms. Diani?
Present.
Ms. Carpenter? Present. Ms. Mohan?
Present.
Mr. Patton? Present. Councilman Rosenberg? And Ms. Stewart?
Present.
Thank you. The next item on our agenda is the approval of the minutes of December 16th, 2021. Everyone should have received the minutes in their package. May I have a motion to approve the minutes?
So moved.
Second.
Second. Any discussion? Hearing none. All in favor of approving the minutes of December 16th, please say aye. Aye. Any opposition? No? Okay. So hearing none, the motion has passed, which brings us to item number 3, the notice of appeal rights. And I would ask, again, our board secretary to provide the notice.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of cert within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. Which brings us to item number 4 on our agenda, discussion and analysis of the complaint and Metro legal memorandum in the case captioned Philip v. Hall. We will start with a request to the Law Department to summarize for us their law memo on the complaint. Again, it should be, everyone has received a copy of it prior and has had an opportunity to review it, but it would be helpful to just hear a summary of it from Ms. Ecke.
Sure. So there are 7 allegations in the new complaint that was filed on October 25, 2021. Allegation numbers 1, 2, 4, and 5 deal with failure to file annual disclosure statements as required by the Metro Code. Every council member is required to file an annual disclosure statement by January 31 of each year with the Metro Clerk. The disclosure statements cover financial information for the preceding year. The council member was first elected in June 2018, so he was required to file the following annual disclosure statements. An annual disclosure statement for 2018, due by January 31, 2019. An annual disclosure statement for 2019, due by January 31, 2020. And an annual disclosure statement for 2020, due by January 31, 2021. The annual disclosure statement for 2021 is due by January 31, 2022. The complaint alleges that the council member failed to file annual disclosure statements for 2018, 2020, and 2021. The complaint also alleges that the council member failed to file a timely 2019 annual disclosure statement. It is the opinion of the Department of Law that allegations number 1, 2, and 4 regarding failure to file 2018, 2019, and 2020 annual disclosure statements as required by the Metro Code, if proven, could support a finding that the standards of conduct were violated. Therefore, the Department of Law recommends that the board hold a hearing on allegations number 1, 2, and 4 in the complaint. The Department of Law recommends that the board dismiss allegation number 5 pertaining to failure to file a 2021 disclosure statement, since the 2021 disclosure statement is not due until January 31, 2022. Allegation numbers 6 and 7 deal with failure to amend disclosure statements to report debts as required by the Metro Code. The Metro Code requires council members to describe debts over $5,000 owed to any one creditor. Loans from established financial institutions made in the ordinary course of business, unusual and customary terms are excluded from the reporting requirement. Debts owed to family members or relatives by blood or marriage are also excluded from the reporting requirements. Allegation number 6 states that the council member failed to report a default judgment of more than $7,000 rendered against him on or about September 20, 2020. Allegation number 7 states that the council member failed to report a judgment of more than $35,000 granted against him and another person on and about May 14, 2020. It's the opinion of the Department of Law that allegation numbers 6 and 7 concerning failure to report the two 2020 judgments, if true, could support a finding that the standards of conduct were violated. Therefore, the Department of Law recommends that the board hold a hearing on allegations number 6 and 7. Allegation number 3 deals with failure to report campaign contributions as required by state law and failure to file a 2019 annual benefit statement as required by the Metro Code. Council members are required to file an annual benefit disclosure statement with the Metro Clerk by January 31 of each year. The benefit statement includes anything of value as defined in the code that was received during the previous year. The complaint alleges that the council member did not file a 2019 annual benefit disclosure statement. It's the opinion of the Department of Law that the allegation regarding failure to file a 2019 benefit disclosure statement, if proven, could support a finding that the standards of conduct were violated. With regard to failure to report campaign contributions as required by state law, the complaint alleges that the council member accepted campaign contributions which were not reported in accordance with state law. The standards of conduct provide that employees shall not violate requirements of state law regulating the conduct of county officials. State law requires candidates for local office to file with the County Election Commission a statement of all contributions received and expenditures made by or on behalf of such candidate. It's the opinion of the Department of Law that the allegations concerning failure to report campaign contributions in accordance with state law, if proven, could support a finding that the standards of conduct were violated. So the Department of Law recommends that the board hold a hearing on allegation number 3 regarding failure to file a 2019 annual benefit statement and failure to report campaign contributions as required by state law.
Thank you, Ms. Ecke. Before we begin to discuss the matter, legal memo, I wonder if does any board member have a question for the Law Department, Ms. Ecke, or the Law Department to clarify?
I just wanted to clarify that today we're discussing whether or not to have a hearing on 1, 2, 3, 4, 6, and 7, yes. Correct? Yes. Okay.
Yes. So the purpose of today's meeting, now that we've had a review of the memorandum, is to decide if we will dismiss the complaint in whole or in part, and if in part, which parts we will go forward to hearing on. And I think if there are any other questions in terms of the legal memo for Law Department, I think what we can do as a board is perhaps look, kind of at each one. The Law Department's memo is recommending we proceed to hearing on all of the allegations with the exception of number 5, as it's unripe. It's not, there's no, it's, so why don't maybe we can take that first? Let's just take number 5. Is there any discussion about allegation number 5 and the law department's recommendation to dismiss that allegation? So may I have then, I guess I'll entertain a motion to adopt the law department's recommendation to dismiss allegation 5, number 5.
So moved.
Second, any second?
Second.
Okay. Any discussion? Hearing none. Shall we do this by roll call or
Yes, ma'am.
right by roll call? Okay, I'd ask the clerk to take roll call.
Ms. Diani,
Yes.
Ms. Carpenter? Yes. Ms. Mohan?
Yes.
Mr. Patton?
Yes.
And Ms. Stewart?
Yes.
That's 5 in favor.
Okay, so the motion passes, and we have moved to and acted to dismiss allegation number 5 regarding the year 2021. Is it law department's preference that we would do each allegation by roll call vote rather than kind of?
It's entirely up to
Okay.
you. You can decide to do the remaining allegations together,
Okay.
or you can take them one by one.
Okay. Is any preference? Okay. So we do have a law department legal memo which recommends going to hearing on the remainder of the allegations. Any preference whether we move, I can entertain a motion to just adopt the law department's memorandum and its recommendations at this point. So moved. Okay, so we have a motion to adopt the recommendations of the law department with respect to the allegations of the complaint, with the exception of number 5, which we've dismissed. That is the motion. May I have a second?
Second.
Okay, we have a proper motion before us. Is there any discussion? Okay, hearing none, then we are ready to take a roll call vote. This vote is to adopt the recommendations of the law department that we move forward to a hearing on the remaining allegations. Okay? All right, Asa.
Ms. Diani,
Yes.
Ms. Carpenter,
Yes.
Ms. Mohan,
Yes.
Mr. Patton,
Yes.
and Ms. Stewart.
Yes.
That's 5 in favor.
Okay, so the motion carries. We have decided to move forward to hearing on this matter, and I think at this point, it's really a question now of a bit of logistics about when we will hear the matter. I will say I will ask the clerk to let us know if there are particular dates in which we would have this room for a hearing room that you'd like to propose to us, and we can check our calendars.
I do not have a list of dates in front of me right now, but I can check and get back to each member as I find out.
Okay. Okay. Well, while we're here, though, why don't we just see if there's some tentative dates where the members will be available. If we look at the, and I guess I would just have us look at, for instance, the week of February 7th. Towards the end of that week, I'm just going to throw out a date since we're all here. So if we can get a date, it would give the parties more notice, maximum notice of the schedule. And so I will propose February 10 for hearing on this matter. And I guess right now I'll just ask the board members, does that look possible? No?
I've got a hearing in a court in Putnam County.
On the 10th? Is it one day? What does the 11th look like?
I have a conflict on the 11th.
February, I guess I'll propose 3 weeks would be February 3rd.
I'm fine after 9:30.
I'm out all day. Sorry.
Do you have a conflict all day?
I do. Leadership Nashville. Yeah, sorry.
Our Thursday's not particularly not good days. I mean, I'll just
No,
move.
they're actually not usually bad. I just happen to have.
Yep.
My February is not very good. I'm wide open on February 9. I don't know about.
The Wednesday, February 9.
Yeah.
Why don't we look at that
That
date?
works for me. That works for me, too.
Mr. Penn.
I've been waiting on y'all to work for me.
It works for you? Okay. So it looks like I'll just ask, make sure the law department and clerk's office are available, and then we'll work out the specifics of the location. But so we're looking at a hearing date of February 9. And we can perhaps tentatively set it for 10 a.m.
February 9th?
It's a Wednesday, February 9
Okay.
at 10 a.m. Subject to confirmation that we'll have a space. Okay. So that is about just a little short of 3 weeks from now, today. I also just want to say in terms of our process and our procedure, I think that every one of the parties have been well informed of our process and procedure and received documentation to the effect. Just briefly, though, we will, in opening a hearing, we then will go to any preliminary matters, including stipulations. So to the extent that there are allegations or factual allegations or facts in the complaint that are stipulated to, this body receives stipulations. And at that point, then, once the stipulations, if there's any, or other preliminary matters are handled, we'll go into opening statements. And then the complainants will begin with their presentation of evidence. The respondent will then present evidence. There'll be rebuttal, and then we'll go to closing argument. So that is generally the process that this board follows. Are there any other logistics or process that would be helpful to the parties that law department would like to add to that?
I just wanted to add that as reflected in the code, if any party wishes to submit material to the board, the party must file the material with the clerk and provide a copy of the materials to the other party at least 7 calendar days prior to the hearing date. So just a general information with regards to any information that, any materials that the parties wish to submit for consideration as part of the hearing.
Okay. And again, I see a request from the, a request.
Just a question, ma'am.
Yeah.
So we previously submitted a large number of exhibits in preparation for the first hearing way back in October. Are those considered, in other words, do we have to resubmit them 10 days prior to the second hearing? Can we provide, obviously, additional? We could, but my question specifically is it the position of the board right now that the ones we've already submitted are properly submitted and we can use them, or do we have to redo that? That's what I'm asking.
To avoid any ambiguities, we will suggest that you specifically specify the materials that you are submitting for this hearing that's going to take place on February 9th, so that there is no confusion or ambiguities. So if you can just either provide us with the document or identify the prior documents that you submitted that you wish to submit as part of this new hearing, so that,
I have a concern here. So we're now at the 13th, and I have to do this 10 days prior. It gives me a very, very short window to put the material together. I mean, obviously we could do it, but I just want to point that out, that really is a time crunch, very short period.
if there's a specific material that you filed with the Metro Clerk, if you just identify that material and said this,
Understand that?
Yeah.
The problem is that there may be the need for me to obtain other documents that I do not have in my possession at this time. And then to meet that 10-day requirement is putting an awful short burden on me on the front end. I'm just pointing that out.
yeah, it's for the board to determine whether you want to move the hearing date forward
Right, but, yeah,
to
later.
maybe towards the end of February or early March, so that there's no issue regarding sufficient time.
It's a 10-day or a 7-day?
Well, the code requires that it be provided that it must be filed at least 7 calendar days prior to the hearing.
Right,
And it also will need to be provided to the other party within, at least 7 calendar
Right.
days.
right. It is 7 calendar days, not 10, but a question has been raised about sufficient time to prepare for hearing, and I guess I will turn that over to the board for discussion. Any comments or thoughts? And I guess I would, also, I request that any other party wishes to comment on the timeline as well. I mean, I don't know if the respondent's here. But
I think so.
I don't.
I also would like to indicate that the code also requires that each party file with the clerk a list of witnesses that the party intends to call at the hearing and provide a copy of that to the other party. This must also be done at least 7 calendar days prior to the hearing.
All right, so why don't we build this into the schedule and make it very explicit to assist in preparation? So we were talking about the 9th. If we moved it back a week, I guess, let me,
I don't have any availability the weeks of the 14th or the 21st. So I was trying to accommodate it earlier, but if we're going to push it, I'm going to have to push it
into March.
probably into March. So it doesn't matter to me.
I understand.
I just can't do it either of those two.
So it would be March.
I don't know if that's a procedural issue with me, because I think my term would end at the end of February.
At the end of February. Well, let's look at this. If we stuck with the 9th, if we count 7 days back, so it would be by January 31st to submit. Did I count that right?
Yeah. I think
Oh, I'm
it's
sorry,
February 2nd.
February 2nd, yes, February 2nd. I skipped the weekend, February 2nd.
Chair, I'm not, sorry
Yeah.
to interject.
Yes.
Is there actually requests that the date be moved, or are you pointing out that it's difficult? Because I think, I haven't heard a request that the date be moved.
No, I think Ms. Ecke suggested that we consider that.
Yes,
but
absolutely, you could
yes.
consider that, but I'm trying to get
Yeah.
some clarification
Right.
because it's so hard with everyone's schedule.
Right, no, I'm thinking we might stick with, given what we've just learned about February's out, and that would push us into another deadline. It's looking like the 9th would be the hearing date, which would mean submission of materials, a witness list and so forth by the 2nd of February. which is, what, 2.5 weeks from now. So, and thank you that's our situation, and we're not hearing a specific request that it be, from anyone that it be moved back.
My preference would be to move it back, I'm sure.
Uh,
But it's, look,
Yep,
you guys schedule it out
Right,
every year. and
right,
we'll do the best.
right. Right.
I'm just pointing out that that is a very short period of time to put it all together and get the notices out and provide comments. It is 2 weeks, but honest to God, I have a real life,
Mm-hmm.
and it's hard to believe. And so, again, if you said at the 9th, we're going to be here, we're going to do it,
Right.
all right? But it would actually be my preference to postpone.
I understand. I think we run into then having to postpone it for quite a long amount of time, well into March, and I think this case has been pending for, I think, since the summer, so I think it is best for us to proceed on the 9th to make sure that Ms. Ecke's direction was clear, that it doesn't have to be a complete resubmission. It could be reference to the filings earlier if you filed with the clerk's office. So we appreciate it, but we'll stick with the 9th, and we have a 10 o'clock hearing on the 9th. Are there any other logistic matters, either from the parties or any board member? Okay. Hearing none, I think we can then move on from this matter. We have our dates. Before we adjourn, I do want to just point out to the board members and make sure that you have it on your calendar, the March 7th annual meeting of the board, which is a Monday. And we don't have a time yet for that meeting. I believe we have this room reserved. And I will ask our Mr. Kyle to kind of confirm or propose a time, perhaps by email, so we can get that on the calendar as well. Okay, thank you. Okay, if there's no other matter before us at this time, I'll entertain a motion to adjourn.
So moved.
Seconded? Okay, we are adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.